p.m. Thursday, September 3rd, 2020. Welcome to the regular meeting of the Village of Pinehurst Board of Adjustment. We do have a quorum present, and I'd like to introduce the members of the board. Before I do that, we do have to vote on David Alzamore being a member of the board as an alternate specifically for this application. So in that respect, do I have a motion? Making a motion, second?
Second.
Cindy seconding the seating of David Alzamore as a regular member of the board for this application. All in favor, please signify by saying aye.
Aye.
Aye. Opposed? Welcome, David. You're official. And now for introductions. Jeremy Hooper to my left. Next to me on my left is Joel Schreiberg. David Alzamore, you've already been introduced to, and Cindy Burnett to my right. My name is Leo Santawasso. I'm the actual vice chairman of the board. Our chairman is not available today because of the COVID-19 restrictions. First order of business is to consider approving the minutes of the April 30th special meeting, the May 7th regular meeting, and the May 27th special meeting of the Board of Adjustment. And let's do them in sequence. Do we have a motion approving the minutes of April 30th?
Can I make a comment? In these minutes, it's just list the last name, where in the other ones they'll say Ms. or Mr. I think the Ms. and the Mr. on there seems more professional. I mean, there's nothing wrong with the minutes, but I just wanted to make a note that that's just a preference. Otherwise, I make a motion to approve the minutes of April 30th, 2020.
Have a second?
Second.
Motion by Cindy, second by Jeremy to approve the minutes of April 30th. All in favor signify by saying aye.
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 Aye. Opposed? Those minutes are approved. Minutes of May 7th, regular meeting. Joel Schreiber making a motion to approve.
I have one correction. On page 3 of 5, it lists the square footage as 32.5, and it's referencing your, which was 35.2 on page 1, and so it's just the numbers are reversed.
Well, no, I had an issue with the actual square footage shown on the drawing.
Right?
I thought it was less than what they showed. So it's a moot point, but
Put my note on the wrong one. Okay, well. Right, it is on the 27th. I'll hold up for a minute.
okay.
Sorry.
So we're still on the May 7th regular meeting. Joel is still going to make a motion to approve. We need a second. Jeremy? All in favor?
Aye.
Aye. Opposed? May 7th regular meeting minutes are approved. Now, May 27th special meeting.
So on page 1, it says that you stated 35.2 square feet of house encroached. And then on page 3, it says the encroachment area is corrected to 32.5. My note said 35.2 on both places.
I'm looking at it, trying to remember exactly what happened. I know I had a question about it. I will accept the change if we want to make a change, but
It didn't come into play in the final, but I had 35.2 both places.
in both places?
On my notes, yeah. So, it's up to you.
Wait for Joel to sit down. Joel, you're still making a motion to approve?
Yes, I am.
Okay. You're going to second the motion with an amendment?
For the 27th,
Yes.
I will second with the amendment that page 3 of 5, where it says, with the condition that encroachment area is corrected to 35.2.
All in favor?
Aye.
Aye. Opposed? Minutes of May 27th are approved as amended. We're now ready for the public hearing, but we need a motion to recess our regular meeting to go into public hearing number 1. I have a motion from someone, please.
So moved.
Jeremy making a motion, seconded by Cindy. All in favor?
Aye.
Opposed? None. We're now in public hearing number 1. And let me introduce the public hearing. The purpose of this public hearing is to receive evidence on an appeal on the official determination of the Pinehurst zoning administrator to the Board of Adjustment regarding an application made by Ben Stahl, owner of subject property. Specifically, this request is seeking a determination from the Board of Adjustment regarding the decision of the Pinehurst zoning administrator in implying the regulatory provisions of a condition associated with conditional district rezoning regarding the location of a fence within a 10-foot undisturbed landscape easement at the property addressed as 822 Winston Pines Drive, Aberdeen, North Carolina. This property is also defined as Moore County PID number 201-80553. This process is a little bit different from what we normally do in planning and zoning, where planning staff introduces the application and gives the background for it. In this case, we're going to hear directly from the applicant as to the status and purpose behind his appeal. So, Mr. Stahl, would you please take a seat up front here, speak into the microphone so we can all clearly hear you. We're going to be not only taped but videoed, and we need to hear what you say when you say it.
Leo, I kind of want to give a little bit of a background, if we could. Also, if you wouldn't mind, thank you for reiterating that we need to speak clearly into the microphones, but that this is a quasi-judicial public hearing, therefore anything presented today needs to be made as evidence of the record, and so will have to be provided as sworn testimony.
All right. Well, I got both of you up there. I'm going to swear at you.
All right.
Raise your right hand, please. Do you, say your name,
Install.
Alex Cameron.
swear or affirm to tell the truth, the whole truth, and nothing but the truth as it pertains to this application?
I do.
Thank you.
All right, so again, as staff, I just kind of want to give an initial background here on the basis of the application made by Mr. Stahl, which is the, as you mentioned, the property owner at 822 Winston Pines Drive. So here's an aerial map of the property in question and a greater view of the subdivision to which this will have some future impacts on. So a little bit of background on the overall subdivision. This subdivision was subject to review and consideration of a conditional district rezoning before Village Council in 2017, and has also required a public hearings before the Planning and Zoning Board just a few months before that. During the public hearings, which adjacent owners are notified, there was plenty of discussion from the abutting areas about keeping the rural character, kind of having some of a buffer area or a landscaped area along the perimeter of the subject 28-acre parcel. The Planning and Zoning Board conducted a duly advertised public hearing. There were many concerns that were brought up during the public hearing. The Planning and Zoning Board decided to continue a public hearing 2 weeks later with an interim one week later meeting of a subcommittee group at the Planning and Zoning Board, the developer, his engineer, and village staff, which I was party to. During those subcommittee meetings and subsequent public hearing item where Planning and Zoning Board ultimately recommended approval of Village Council with conditions, the language of the 10-foot landscape buffer to remain as undisturbed was brought up at that point. Again, ultimately, the Planning and Zoning Board did recommend approval with conditions to Village Council. In their regular September meeting in 2017, Village Council did approve the conditional district rezoning and the general concept plan, and that is included as Exhibit C in your guys' packet. And just while I'm at that, I would now like to formally introduce the packet material that was provided to you guys by Friday of last week, which includes Exhibits A through Q. Minded there will be and can be additional exhibits entered into the record for your review and consideration. So Village Council approved the conditional district rezoning with the conditions. After that, the developer was then allowed to and proceeded to secure all the required and necessary development approvals in order to install the required infrastructure and then plat the subdivision. And therefore, after the lots being created, then homes could be constructed on. So that brings us more into present day times instead of 3 years ago. That 10-foot undisturbed landscape easement, which was shown on the general concept plan and again reiterated as a condition of approval, was shown on the final plat, which is included as Exhibit E within your packet. Now we're to the subject property here. This address is 822 Winston Pines Drive. A fence permit was applied for that property on October 1st, 2019. The individual staff that is usually responsible for the review and issuance of these permits was not aware of the condition of the 10-foot undisturbed landscape easement. Late in December of 2019, two separate incidents were sort of occurring simultaneously, which brought this subject fence permit up to the surface. Staff, as indicated in your guys' packet, did receive a complaint from a nearby resident, as well as myself in reviewing other fence permits during the holidays as folks were taking time off, realized another fence permit in the area was applied for, and then that's when I started catching the 10-foot undisturbed, and how are we going to apply this? How do we apply it now to the 822 property? And subsequently, how is it going to be applied to the perimeter of all the perimeter lots in this subdivision? So after the holidays, staff started having quite a bit of communication with the fence contractor on the application, as well as ultimately with the property owner, which is when we first got in contact with Mr. Stahl. Through several weeks and trying to come to an amenable solution, we ultimately decided that the fence could not be located within that 10-foot undisturbed landscape easement and gave a couple options to Mr. Stahl on how to move forward. Exhibit B is the signed official determination letter, which was made by Darren Burrich, the Planning Inspections Director, on the location of the fence and it not being allowed within that buffer. And that was ultimately through, after a little bit of a mailing issue, delivered to Mr. Stahl at his personal property. And he did submit an appeal application within the 30-day window. Here are a couple of items in how and reasoning and background of why the zoning administrator did make the ultimate decision. You'll see on the top right there of this slide is Ordinance 1712. So this was the approved ordinance that had the condition language number 5 as follows. A landscape easement shall be provided along the rear of the proposed lots adjoining properties to the subdivision as shown. The landscape easement shall be 10 feet wide and shall remain as undisturbed. Below that, you see the approved general concept plan that was associated with that rezoning. I know it's a little hard to see, but the highlighted areas are the 10-foot easement area along the perimeter of the subdivision, and the little note there does label it as such, 10-foot landscape easement. The little snip image to the left is of the approved final plat, which then again carries that same language and that same delineation along the perimeter of the subdivision plat. In making determinations relative to zoning regulations here within the state of North Carolina and as outlined in the Pinehurst Development Ordinance, you look at the intent and you look at definitions when definitions are applied within your local ordinance. If definitions are not available in your local ordinance, then statutes, largely because of case law, and also reinforced within the development ordinance, you go to the latest Merriam-Webster edition, and our PDO does define a fence as a structure 18 inches or taller used to delineate a boundary or as a barrier or means of protection, confinement, screening, or as an aesthetic component of landscaping. With that definition, staff was a little unable to come to a clear determination, so that's what led us to the stronger language in the condition, which is shall remain as undisturbed. So the PDO does not define undisturbed, so we went to Merriam-Webster, which undisturbed, not altered or interfered with. And subsequent to the development being approved, a homeowners association was declared, and of course covenants and restrictions. Staff was not made privy to any of the covenants and restrictions, as we typically aren't unless there's some related condition to be. What you will see is Exhibit I is the original declaration, and there's some section in there relative to fencing. And then you'll see that in June of 2019, revised covenants, which I'm sure there have been several amendments or there might be more since then, which is labeled as Exhibit J, speaks specifically to the location of fences within that 10-foot landscape easement. And this is to show that obviously there was some steps being made by the members of this homeowners association at the time, the developer, and then the builder at the time that was coming in and had acquired ownership of most of the lots, to clarify some language about what can or cannot be completed within that easement. Ultimately, we would have, as staff, loved to have been party to those discussions and ultimately the recording of those documents. However, we weren't able to secure that. Within the appeal application, the property owner does mention some impacts to septic. All of the 28 lots within this subdivision are served by septic, but by public water. So within their application, and you'll see some correspondence labeled in your guys' packet as Exhibit N and O, permits and septic operation permits issued by Moore County Environmental Health, it would appear there could be some impacts potentially to the location of this fence. However, I have had some communication as recent as today with staff members of Moore County Environmental Health that due to fencing not being of a permanent construction or permanent foundation, there could be the opportunity to allow for the placement of the fencing at least lying within that 5-foot area of the drain lines, as long as the posts were not constructed right over the drain lines. I would like to mention that even though there could be some impacts, depending on the decision of the board in this public hearing today, that the action that was made by the zoning administrators, whether or not that fencing or other similar structures can be located within this undisturbed landscape easement, and you should make your decision solely on that merit and not on if there are other impacts. So the action by this board, again, as Chair Senator Wasso mentioned earlier, it's a little different than how you guys normally rule and act in your other respective duties. But upon receiving this application of appeal, we as village staff prepare this packet for you that includes all the communication, kind of giving all the background and what events led to us to come into this point. Either at this public hearing or at subsequent public hearings, if it's determined that more evidence is needed in order for you to come to a decision, your decision can be either made in affirming the decision of the zoning administrator, You can reverse the decision of the zoning administrator, or you can modify. In doing such, you do have a decision document in which you need to use as guidance, which a draft is included within your packet, and how you arrive and make your findings. And there's another important item that the Board of Adjustment shall not reverse or modify contested action unless it finds that the zoning administrator erred in applying this zoning condition. Finally, the Board of Adjustment shall not reverse or modify any of these contested actions unless there is a concurring vote of a majority of your members. So this is not like a variance where a supermajority or 4 or 5 of you needed. Simply affirmative vote of 3 of you guys, whatever the outcome would be, is enough to make a decision. Also, it might be important to note that any conditions imposed as a conditional district rezoning are both mutually agreed upon by the property owner, contract purchaser, or developer, as well as the governing board, village council, and no conditions placed on such can be varied by the zoning board of adjustment. So again, this is strictly an appeal and not any type of application for a variance. But that's going to conclude the part of staff that's kind of giving a background and reason why we're here. Again, we'll let the appellant and anyone else who has sworn testimony to give on the application do so. Myself and the zoning administrator who made the decision are here to answer any questions or be cross-examined if needed.
Thank you, Alex. We'll have probably questions for you later. Mr. Stahl, present your case, sir.
Got some PowerPoint slides I'd like to go over. I believe. Okay. That one, yep. All right, I've been introduced, so this slide is kind of redundant. What I wanted to review is kind of the timeline of the sequence of events that happened up to, closer? Okay. The timeline for the sequence of events that happened prior to our purchase of the house, some site pictures, some of the issues that faces me and my wife and family as a homeowner as far as relocation, and then some closing comments. Before moving here, we started looking online with different, real estate, online real estate services, and then on August 20th, we started working with Pam Hill with Elite Properties. Part of our struggle with finding a residence here was really revolved around the fence, which eliminated a lot of the homes that were potential purchases for us due to having the 2 dogs that we have. But the main 4 criteria that we gave Pam Hill, which is also what we used prior to engaging with her, was must be located in Pinehurst, had to have a large backyard for the dogs and children, minimum 4-bedroom, 3-bath, and must be able to be fenced in, no exceptions.
Is that date of 8/20/2020 correct?
2019, I apologize, that's a typo.
Thank you.
Yes, sir. And same with this one. Should be 2019, I'll fix that and resubmit. On 8/20, we looked at it, probably, I don't know, well over a dozen homes. I stumbled across the Winston Hills one on a site, brought it up to her and said, where is this? Because we couldn't find it on Google Maps because it's a new subdivision. Didn't give us the directions. She was able to find it. And as you can, excuse me, I apologize. As you can see, based on my wife's email to our real estate agent, she said that house just checks all the boxes for us. And that being the 4 pieces of criteria that we initially set up for the house. Fence, the large backyard, Pinehurst, and then the 4-bedroom, 3-bath that we were looking for. On August 26th, we inquired with the listing agent through Pam Hill about fencing and screening in the porch. The house was probably 90 to 95% complete. We asked about adding that. We were provided pricing by the listing agent. At that point in time, I said I'd like to see the CCRs for the subdivision and how does fencing work in there. What I didn't want to run into is the double fencing where people hold off. And they said, nope, it goes on the property lines in the rear, goes on the property lines on the side. There's an easement, we were told about an easement, and they said, don't cut anything down. It's basically a landscape easement. I was familiar with those, so I didn't really have any issue with that. The two attachments at the bottom, and this particular one is an image, but the same CCRs that were submitted, I think it was one in January, and then the one that was the amendment in June, showing the specifics around the fence, which the amendment showed the exact size, height, construction, exact location. It specifically said where it could be placed. This is the paragraph I pulled out of that CCR for the subdivision. And if you notice, rear lot boundary line in bold, it says walls and fences shall extend to the rear lot boundary line despite buffer reservations, so long as no trees are felled when fencing along or to the rear boundary line. Basically, I won't read the whole thing, but it says if there's a tree in the way, then you move the fence forward to avoid the tree, and then you would, have to push that fence up. It also says it, and no more than 5 feet from the rear lot boundary line, okay? This was the addendum that was for the condition of sale for the backyard fence included and the screen-in porch. This is prior to closing. Again, this is 8/29/2019. Apologize for that typo, I'll fix that. On 9/5, we got the executed back from Cavanis and Cates and the listing agent, showing we had entered into contract for the purchase of the home. On September 26th, Cavanis and Cates, who still owned the property at the time, submitted their permit application. It was received by Pinehurst on September 26th, and LMS and Sons were the ones who were the contractor to put the fence in. The original fence request and permit was submitted, like I said, in September 2019, prior to our closing date, and as a condition of sale for this house, and was subsequently approved by the Village of Pinehurst. I specifically asked about whether the fence would be located on property lines to ensure we lost no real estate, the installation of the fence, and understanding what those boundaries in that easement meant. We were provided the CCRs prior to making an offer. That's a legal document filed with Moore County Register of Deeds. I was assured by the builder, the developer's CCRs that we received, the real estate agents, and the Village of Pinehurst, by their approval of the permit, we would have full access to our entire parcel of property for which we were paying for. The fence was installed per the city-approved permit and per the HOA guidelines prior to the purchase of the home. And just a note, there was another house that I think kind of triggered some of this. They added a fence. They moved in after us. Their fence was held off 10 feet, and they renegotiated the price of their sale of their home due to the loss of that 10 feet because the CCR said one thing at that point, and then apparently it wasn't allowed once my fence came into question. So they actually negotiated pricing on that. So on October 11th is when we closed, 2019. Again, I'll fix that. The timeline for the complaint, I was first notified by, the first contact I had with anybody with any concern over the fence was on February 14th of 2020. And one of the supervisors, I think his name was Gary with Cavanis and Cates, basically came up, knocked on the door and said that we have to move our fence, and said that the city says it's in the wrong place. I didn't really get much detail, and I said, what are you talking about? He goes, we're trying to schedule, and he's doing this rambling fast talk, which was, I was like, time out, we're not doing anything. I need to talk to the city, what's going on? And he didn't have a good answer why it had to be moved. At that point in time, I asked him who he was dealing with. I was given the name of Darren Burek. I've reached out to Darren Burek, and at that point in time, we discussed that easement, and there was not clarity around what that easement meant, if it excluded fences or didn't. And I asked for documentation, and they said there were meetings and there were maybe minutes, but there was nothing really documented or specifically referencing fences within an easement. March 13th, and I won't go through all the dates, but it was the same thing that he went over earlier. I received a determination letter, signed it, and then I submitted the appeal on April 27th. And on the slide you had earlier, the Village of Pinehurst says they didn't have a copy of those CCRs. I don't know when they got them, but when I first inquired about this, I was given in an email by Darren, and I'm not throwing anybody on the bus here, I'm just statements of fact, right? On February 14th, I was sent this email by the Village of Pinehurst with the two attachments that had the original covenants as well as the amended covenants. that were in that email, and I said, I already have those, and that's why we built the fence. And I said, that's exactly, supports my case. And that was where the even more confusion came in, trying to figure out whether this was right or wrong or needed to be fixed. So when I asked for a written copy for definitions and restrictions of an undisturbed landscape easement, the city responded they had no such clarifications. I've scoured the website. There's really nothing that I was able to find on the Village of Pinehurst website. All I've been able to secure are vague generalities around what this easement actually is, which is still unclear and yet undefined, hence this meeting today. When a reasonable person looks at their words in various combinations, they're able to surmise their meanings. Combination of undisturbed and landscape would imply protection of the existing flora and terrain. And in fact, the HOA CCR document reinforces that implication in that it says, preservation of trees, you can put the fence up, but, preserve the, existing flora and not cut it down. It's unreasonable to expect any homeowner to comply with an ordinance for which no written explanation or restrictions exist. We complied with the ordinance by purchasing a home with fencing approved by the Village of Pinehurst and complies with current CCRs filed with Moore County Register of Deeds. Furthermore, there's no mandatory monitoring or ensuring this ordinance is honored by any homeowner within this development or the developer, or the builder at this time. There are no before pictures. There are no after pictures of the 10-foot areas showing changes in the easement. On any of these parcels, there are no tree surveys performed. You cannot effectively enforce this going forward. I mean, it's extremely broad and vague. I was on the HOA board for landscaping, as the board member for landscaping in a very large development in the city of Charlotte. We had landscape easements. Some people call them buffers, some people call them easements. In essence, they're one and the same. Fences were not restricted from the areas. They are not legally considered permanent structures or development. They're considered temporary structures. The restriction were focused on development, like sheds, houses, swimming pools, outbuildings, anything else along those lines. Those areas were, there was audits that were taken prior to a lot being developed. Trees were measured, survey was done. They'd come back after the fact, remeasure and count, make sure that everything was as it was prior. If not, then they had to replace like in kind. And in this particular instance, we don't really have any form of enforcement of that. Now, if you look at the aerial map picture that was shown earlier, this is the area of the fence location and the undisturbed landscape easement. You can see that there are substantial trees in that zone currently. From about the number 822, there's probably maybe 10 trees in and around that white triangle. The remainder from that white triangle to the rear of the property line is barren, okay? There are two small trees within that 10-foot zone that are approximately this big around, about 4 inches. They're both next to each other. They're on the far back bottom right corner with that orientation, that slide. So there's nothing back there now. This is the area of the fence, just without the vegetation piece, and it shows the next closest residence adjacent and then our neighbors across the street. This is the pre-closing pic from the rear property line, southeast corner. This is me standing on the property line looking at the back of the house. As you can see, there are bulldozer tracks, sand, and everything else. There are no trees there. That tree that you do see is approximately 15, 20 feet forward inside the property line. It's not in that 10-foot zone. Directly to my left, not in that picture, the two trees that I mentioned, they're roughly equal to the size of that one, and they're approximately 6 feet apart, but they are within the 10-foot zone. This is roughly from east center of the lot, looking at the back of the house. When I talked about that white triangle with the 822, those are the only trees left on that lot in the rear, from the rear of the house, okay? Everything else back there it's barren. There's a small distribution box, and just to clarify, let me go back the other way. From this slide, if you're facing the rear of the house to the right, and again, I'm standing on the property line, so you're seeing what's on the property. To the right, probably about where it says attachment 10 on this slide, if this picture were to take up the whole screen, there is what is known as a D box, or a distribution box for a septic system. It is circled in that picture. None of those trees in this picture are within that 10-foot zone. They're approximately 30-plus feet away from the fence, probably closer to 40. But I'll have a better picture. I'm just giving you perspective from the house to the back corner of the property. The round item there is what is known as a lift station. There's a pump in there, so the septic tank, as it fills, it overflows into that lift station. That's the electrical supply to it mounted. Once it goes in that lift station, that pump then pumps it to a pipe that goes to the left, and it goes straight to the back of the property line. And it is, I'll show you another picture in a minute. Not a real good picture, you can't see. That orange arrow is pointing at roughly where the 10-foot mark is in the fence. It's hard to see with where the corner is. You can see the two trees I'm talking about that are to the left of the arrow. But there's nothing left. There are no trees. There is no undisturbed landscape in this 10-foot easement currently.
Was your lot one of the first lots cleared?
It was one of the first 5 houses built in that subdivision, yes. We were the second family to move into the subdivision. And the first family is right here. They do not have a fence. In fact, a lot of people are holding off on fences right now because there's a lot of confusion around this particular issue. Everybody's kind of on pause until this gets resolved.
Alex, are there other properties that have this same condition now?
Well, I would say all those perimeter lots, this 10-foot undisturbed landscape easement, and thus this decision.
But has any other lot constructed a fence on the rear property line
No, sir.
obstructing the 10-foot easement?
There is no other fence located within the 10-foot easement.
Thank you.
But there is clearing that's taking place.
Pardon?
There is clearing that is taking place. Based on the pictures, one can see there are no trees left in the 10-foot zone due to the installation of the septic drain field lines. No actions were taken against any contractor at any time concerning removal of trees in this 10-foot easement during the construction. I'm just curious, why now? What is the issue now that we've moved in and now we're dealing with this and there's not been a point? Like I said before, 10-foot area has 2 original pine trees, plus or minus 4 inches. Relocation of fence provides no beneficial landscape advantages, as it's technically a xeriscape, currently consistent of pine weed and weed grasses. There is no residence directly behind our house, so the visual aspect is 0. The septic plan filed with the city of Moore County. This is the overall permit. Lift station, like I said before, with a distribution box, and it has 3 serial lines at the rear of the property. This is a close-up of the hand-drawn. Just to note, does this have a pointer on it? I don't remember. Let me go back. You can't hardly see, but right above the picture, it says, drawing is not to scale. I just want to make sure everybody understands that. That also means that this number right here that says 13 is not 13, it's actually 12, okay? That is the current septic tank. That is the distribution box, lift station that we saw earlier with the round lid. And then that pipe goes to the side of the property, approximately 11, 12 feet off. It runs parallel to the side of the property. It runs to the back of the property. These septic lines run 60 some odd feet. They're in varying lengths. And I'll get over the measurements on the chambers in a second. But that distribution box is 12 feet off of that fence. From this fence to the edge is 12 feet. You can see a little better perspective in attachment 14. They were supplied, I don't know if they have copies. But in the picture, you see a red arrow pointing down. That's the distribution box in relation to the fence if you're looking back towards the back corner. So relocating the fence 10 feet from the property line will affect future access for maintenance or repair to the distribution box, leaving less than 2 feet for access and or maintenance, and it compromises the septic drain field. In addition, Jane West, like we said before, she required 5 feet off of the drain line. Those lines run parallel to that back fence. I have seen 4 different renditions for this house's septic plan. The one that was filed, the one that is in this packet is the most accurate. We actually had the septic tank guy, Garner, come out, and in this picture, roughly in this area of the drain field, there was an area that had washed out and they had to repair. Those chambers and I'll just kind of go over it. Each drain field chamber is 3 feet wide, okay? So you have a distribution box that's this big, and then you have a chamber that's 3 feet wide. And then that constitutes your drain field. There's 6 feet of separation between each of those lines. So the first line, the main line, runs against the back of that fence. In the discussion with him, he said they run it 10 feet off the rear property line. So moving the fence up, you actually put it into the chamber, into the physical pipe. And due to the lift station, this really will affect other residences within this development. There is another house that I'm pretty sure has a lift station. They've cleared their field in the back end, that 10-foot easement on the opposite side of the subdivision. In addition, when we were given the lot, we're given the square footage and the acreage, it's like 0.58, and moving a fence ends up in a reduction of, basically 1,130 square foot reduction of property. At no time did any person or entity provide us with any conflicting information stating we'd not be able to have access. Not saying we want to do something with it, but have access to a 10-foot strip at the rear of the lot. The CCR is filed with Moore County Register of Deeds and approval by the city of Pinehurst just basically reinforce that reasoning. And like I said before, it's 1,130 square feet, of which, goes away basically. It's unfair and unrealistic to expect a homeowner who is given information through CCRs and real estate agents and the builders and everybody else, and then expect to pay full price for something that now we lose after the fact, and then taxes on something that is now removed from our ownership basically. Had the city denied the permit at the time of the application prior to closing, then this would have given us time to re-examine the purchase of this property. As a result of this oversight, we found we could potentially own a parcel of property that is reduced in size and now affects future resale of this home. We find this out, after the fact. That was the easement definition, okay? A landscape easement, I'm not going to go through, everybody has it in front of them. I think they've read it. But basically, when we talk about rule of law is a principle under which all persons, institutions, and entities are accountable to laws that are publicly promulgated, equally enforced, independently adjudicated, and consistent with international human rights principles. Fourth one doesn't necessarily apply here, but the other three definitely do. Being that city ordinances follow the rule of law. Now this thing's not working. I just went on strike. There it goes. Void for vagueness is a doctrine that discusses the legalness of laws and ordinances. In this particular one, void for vagueness technically applies to criminal law, but it is a basis for common law ordinance and statutes. In criminal law, declaration of law is invalid because it is not sufficiently clear. Laws are usually found void for vagueness if it's after setting some requirement or punishment. The law does not does not specify what is required or what conduct is punishable. Under vagueness doctrine, the statute is also void for vagueness if a legislature's delegation of authority to judges and or administrators is so extensive that it would lead to arbitrary prosecution. In property law, declaration that a deed or other instrument purporting to affect property rights is invalid because it lacks a sufficiently clear description of the property. I think this battery's just about gone. Oh, there we go. So void for vagueness doctrine requiring laws to be drafted in language that's clear enough for the average person to comprehend. If a person of ordinary intelligence cannot determine what persons are regulated, what conduct is prohibited, nor what punishment is imposed under a particular law, then the law is deemed unconstitutionally vague. Government must clearly distinguish what conduct is deemed lawful and unlawful. This doctrine prevents the arbitrary and discriminatory enforcement of laws. These laws must be understood by both those required to obey them and those required to enforce them. This doctrine discourages judges from enforcing poorly worded legislation. The owner, myself, did not act with specific intent to commit an offense. I did not act willfully, knowingly, or deliberately. Therefore, the owner, should be held harmless for any punitive sanctions. And if we talk about laws being drafted in language that's clear enough for the average person to comprehend, we have this village clerk and I guess the complainant don't understand the ordinance. There's confusion around that, and one is a employee of the city and one is a resident, and they don't understand it. And then just to, if we talk about, the second part of the void for vagueness is not understanding the punishment, what's being enforced, what's lawful and unlawful. And in your packet, you have these emails. There's a long, nice paragraph of discussing this particular thing and not understanding what that is, and talking about the condition approval, putting a fence in there is disturbing that, unless someone else, Jamie or Alex, you tell me differently. So again, you've got a planning and inspections director, that doesn't understand this easement ordinance definition, right? And then, again, the doctrine prevents arbitrary and discriminatory enforcement of laws that have to be understood by those required to obey them as well as those required to enforce them. And then again, you still have this confusion around this easement from a senior planner with the city, and he's required to enforce something but still doesn't understand this particular ordinance. I found there are numerous examples out there. I just happened to pull one offline, but it talks about what, for landscaping buffers. And traditionally, when there's a landscape buffer, there are things that are put into place that understands purpose and intent, general standards. This does not exist for this particular easement. Again, it's extremely vague and does not really define, what is undisturbed, what is landscape. Does landscape include a fence? Is it just plants? Is it the land? Is it the ground? So just examples, this would be a well-drafted landscape buffering definition that would provide a lot of clarity for owners. And second part shows preservation of significant landscape features, tree preservation and replacement. So it defines what is being preserved. It gives you an idea of, there's tree surveys that are incorporated. If they're greater than a certain caliper, in this instance, if they're greater than 6, they have to be preserved. Replacement trees must equal the total number of caliper removed. So if you cut down a 20-inch tree, you can plant 4 or 5-inch. That satisfies the requirement. So this is clarity. If we had something like this, we wouldn't be here.
Well, we don't have something like that. And all we
Correct.
can do is go by what we have.
Correct.
Right?
And then the final piece of it is, talking about the rule of law and void for vagueness. The other piece of it is if you do not abide by the easement or the buffer, then there's a penalty, and it specifically lays out exactly what you're being required to do as a penalty. So this ordinance should be considered void for vagueness per constitutional rule. The undisturbed landscape easement ordinance passes every test for the vagueness doctrine. It does not explicitly state nor define what is punishable, restricted, and therefore is not sufficiently clear. It does not provide fair notice of the conduct being regulated nor what those punishments entail. It also grants the Village of Pinehurst arbitrary enforcement with unstructured and unlimited discretion to include ex post facto ordinance enforcement, reversal of a legally approved permit, and a bait-and-switch real estate transaction as is happening in this case. The delegation of enforcement authority is extensive and unrestricted due to the vagueness of this ordinance, leaving homeowners at the mercy of arbitrary interpretations and enforcement of the current ordinances. My wife and I would like to personally thank everyone for their time tonight. I do appreciate it. Our goal was to find a residence with specific criteria where we can make a home for our family. The Winston Pines home met all of our requirements, hence the purchase. This entire fence issue has been extremely stressful and a lingering burden on our entire family for, since February, basically. I appeal to the Village of Pinehurst to make the right decision based on my supporting documentation. Relocation of the fence will unfairly harm our family and the value of our property as it was advertised and as it was purchased. I trust the board's decision is based on findings of fact, and the conclusions of law are based on the rule of law. That's it.
Thank you. Is the fence on the rear line on your lot right on the rear property line? Is it offset, or is it right on the property line?
Probably inches.
Beg your pardon?
Inches.
Alex, a question. If you can answer it, what do covenants and restrictions of homeowners associations have to do with any ordinances?
So homeowners associations, covenants and restrictions can go above and beyond any development regulations or restrictions that are in place for zoning and land development. However, they cannot rule against or contrary to. So thank you for questioning that. I was wanting to bring that up. One thing I also failed to mention, as Ben, Mr. Stahl did, clearly give a very detailed timeline of events. It has taken a while for us to get there, and I want to say that we have been in constant communication with Ben after we noticed this issue that had came up, and it's taking this amount of time to get before the board for obvious reasons during the state of emergency that we've been under with this pandemic. So I wanted the board, as well as everyone in attendance, to know this is not any stalling or anything that we've been doing. We've been in communication at least once a month since
Yeah,
then.
I
Thank you.
can affirm that. It wasn't a letter in the mail and, shock and all type thing. It was constant conversations, lots
We
of
appreciate
questions.
your cooperation.
Right, thank you.
No, you did not have anything to do with clearing a lot. That was done by
I have no
the
idea.
developer?
I have no idea who did it.
Okay.
I was not there when that happened. That was existing conditions when we saw the house.
All right, board, questions of the applicant or Alex?
Hey, Alex. Can you just help my understanding a little bit beyond maybe, our PDO and maybe what steps that we would take in this circumstance? Are there any North Carolina statutes, laws, ordinances, or governances upon Pinehurst here on what steps that they would require that the village to take to rescind a permit in this manner?
So that would be governed under general statutes. Depending on the jurisdiction at this point, it would be a general statute, Chapter 160A or Chapter 160D. So it would fall under revocation of permit. If village staff determines that a permit was issued in error, we do have the authority to revoke that permit. So that's sort of the instance that was starting to take place here. If we were to revoke the permit, then the property owner is then in violation of the development ordinance, and then we have to start enforcement of such violation. If an appeal application is made, which was the avenue based on the options that staff given, considering the language of this condition, in order to come to a clearer interpretation and how to define this condition, not only for this property, but for the entirety of the subdivision. So we do have a staff, and every staff with zoning development regulations with the state of North Carolina, the ability to revoke a permit if we have decided it was issued in order. And any action, whether it be the issuance of a permit, the revocation of such, or an official determination like we're here tonight, can be appealed and then go before this board to adjudicate that decision.
Are there any timelines abounding that?
Reasonable. The definition is reasonable, within a reasonable time period. What would be reasonable? Now, and a person with standing would have a 30-day time window to appeal the application or determination made by the Village of Pinehurst. But I'm not aware if there is a clear timeline in when an application is submitted, made, and then issued for a permit before the Village of Pinehurst can then revoke it. When you start looking at other statutes, there's some authority about 7 years plus. Again, I'm not aware acutely of any 6-month or 365-day window of when, okay, it's issued, it's there, we can't revoke it now, whether it's made in error or not. If it erred, it erred.
So I guess the planning staff and the village feels that we're within that time frame of reasonable, certainly given our circumstances.
And then again, as shown within the evidence here, that, late September, 1st of October, submission to issuance of a fence permit to the determination being made in February, we were within our bounds for that. We do feel, yes.
One other question, then I'll let someone else go. So when the HOA CCRs are filed with Moore County, there is not a stop, or is there a process for a municipality as Pinehurst to review and approve them of such?
There's not. Typically, we are made party whenever they're in early draft form, when construction and infrastructure are still going in, especially if there's, if there's going to be a pump station maintained by the HOA, or there's private streets, private roads within a subdivision, we want to ensure that there's an HOA there to have general upkeep and maintenance. Yeah, or if there's some other condition of approval that we need to ensure is safeguarded, we are typically asked to take a look at. But there again, just as the covenants and restrictions can't enforce something against the zoning regulation, we can't necessarily enforce or dictate what is declared within those covenants and restrictions.
No way to find any conflicts within until there's an issue possibly.
Sometimes, no, unfortunately.
They are public record. I mean, if somebody wanted to look, they would have to know, or they made a change.
Or we could go look them up, is what you're
They
saying.
are public
Of
record,
course,
correct.
yes, sir.
So it appears to me that there's a lot of noise, that everybody followed
I don't think it's that. Try it. Get him a different mic.
How'd you get so smart? Thank you. It appears to me that everybody here has certainly tried to do,
Get a little closer, Joel, or yeah, thank you.
it appears to me that everybody here has tried to do the right thing. Am I correct?
Well, I don't want to speak for anyone other than myself or my colleagues here, but yeah, I mean, we as village staff, we do try to go above and beyond and ensure that, our customers are satisfied with what level of service we provide, of course. I certainly wish that actions could have been handled a little bit more swiftly and been a little bit more concise with what information we were given with the development approval. However, at the end of the day, as the appellant has stated a few times, this has implications on one property and 27 others. And so we wanted to make certain we were making the best decision we could with what tools we had within an appropriate time frame.
It appears to me that Mr. Stahl
Yes, sir.
has done everything he could have done to try and comply with, or to comply with, whatever the rules and regulations were.
I wouldn't disagree that Mr. Stahl's involvement came at a very awkward or unique time with being one of the first homeowners, purchasing the lot with some contingencies that were based on approval of the village and were obtained.
If there had not been a complaint, we wouldn't be here in all probability?
I can't say that for certain. However, if you see within the exhibits provided there, albeit almost 3 months after Mr. Stahl's fence permit application was approved, in the holidays, this is probably no surprise. The village staff does try to stagger time away. So I was in the office the week of Christmas. Other staff members were not. I was kind of checking staff's inboxes to see if there was something a quick item I could take, such as a fence permit. And lo and behold, I believe it may have been the lot to the south of Mr. Stahl's property, a fence application was made. And so I started going through the process of review, and I noticed where it was, and I thought, oh, wow, that's something I've never thought about, is I've been very involved with this subdivision from the beginning. I'm not typically involved with fence permits after the lots start to be established. And I thought, okay, well, let me leave this on the desk for everyone to get back, and we can discuss later. And then that just happened to be also within the time frame of when we did receive a complaint. So I do feel like we would have had that discussion internally as staff. Let's say Mr. Stahl, I can say this with certainty, if Mr. Stahl's fence application was within 10 feet of the rear property line, therefore not impacting this 10-foot landscape easement, that staff would have had a discussion about, okay, we haven't run into anything yet. Let's see what we need to do in order to determine that we're not in a situation that we are in, unfortunately. But I do feel we would have had those discussions, but we would not have been before you guys with an appeal, no.
When you purchased the home, it already had a certificate of occupancy?
No, it was still under construction.
No.
It wasn't, we didn't get that until, I don't know the exact date, but we didn't close until October. By the time we closed, the fence was done and the screening porch was added. So they were both added. It was weeks before closing.
So the village came out and issued a certificate of occupancy when this fence was there.
What was the time frame on that, Ben, again? Would you?
It would have been, I think we closed October 11th, so the fence would have been completed by then. I don't recall the date on it, but the fence probably would have been up by then because the house was still being finished after the fence was completed. Yeah.
But would you come up, please, and
I'm as deaf as a
let us
doornail.
get you on tape?
Have to swear her in, too.
Either way. Before you start, please tell us your name, address, and do you swear to tell the truth, the whole truth, and nothing but the truth?
Christy Stahl, I live at 822 Winston Pines, and yes, I do swear to tell the truth.
Thank you.
My point is, we couldn't have closed on the house and moved in the day if we did not have a CO, right?
Yeah, I can't hear you. Just move in closer.
We would not have been able to move in the day of closing without the CO. So the
understand.
CO was issued before the fence was complete.
I understand. So
Okay. I guess I was unsure of where that was going.
I know that. Thank you. So the CO was issued after the fence was built, and obviously, as you state, I know this, before you moved in.
Yes. Yes, it was new construction, so there was no one living in it previously. And so the house was not fully completed when they did the fence. It didn't even have the sod. As you can see in that picture, they were still doing sod about the same time they were doing fence.
I'm just trying to determine, somebody from the village came out, the fence was there, the house was completed, they issued you a CO to move into the house.
Right. And that was kind of my point about the arbitrary enforcement is that this entire piece, that, land has been cleared. It's now it's a wasteland. Septic tank was installed, so there was a septic permit, inspection. So, I mean, there have been a lot of officials looking at this the entire time, which goes back to the vague writing of this particular ordinance is that nobody understands it, including the people that are, required to enforce it up until a complaint, and then it kind of triggers the, what do we do now type situation, or what does this really mean? And
Well, the reason I'm getting to this is that everything I'm looking at here, every plat you have, shows this 10-foot buffer.
yes, it is on the plat.
It'd be a little hard for folks to overlook this.
No, it wasn't overlooked, but we're also provided with a legal document filed with the Moore County that states how specifically, I mean, in minutia, exactly what a fence to be constructed about, how it goes on property line side, whether it's a side lot, front yards, I mean, it's very detailed. So as a homeowner, Most places you go to, you don't go through every single ordinance within a city. You go by CCRs, which generally reflect and are more restrictive than the city ordinances or county ordinances.
Thank you. Somebody had a question.
Well, would you come up to the microphone, please? Name, address?
Afternoon, Lindsay Schofield, 818 Winston Pines Drive. So
Let me swear you in, please. Excuse me. You swear the whole truth, to tell the whole truth and nothing but the truth associated with this matter.
Yes.
Thank you.
So I know you were asking when their fence was put in. I was actually just checking my emails because I was on vacation. And when I came back by October 5th, their fence was placed, so they weren't even moved in yet. And he left end of September, like say September 25th or 26th for vacation. So before I left, their fence was not there. When we returned, their fence was there, and they still did not close on their home yet.
Thank you.
I didn't know if that helped.
Next.
I have a question about the owner, I think it was Ken Bass, who agreed to this, okay? And are you still involved?
Name, address?
Ken Bass, 120 Chesterfield Drive, Pinehurst, North Carolina.
You swear to tell the truth, the whole truth, and nothing but the truth associated with this matter.
I do.
Thank you.
Okay, so give a little previous history like Alex did. When we did the development, this is my first development, obviously, we agreed to the buffer around the perimeter, basically to try to appease as many people as you can when you're having these things. People are yelling at you and calling you names. So we tried to keep from just clear cutting, or keep whoever was going to buy the lots from just clear cutting the lots, hence the buffer in the back. We figured if there were no trees already there, we did not want to take property away from people because that's what this development was, larger lots out in the country. So there was a 10-foot, I actually originally thought it was a 5-foot when we first started talking about it. I think Leo was in a lot of those meetings, and so was Alex. But it ended up being 10-foot. And if you read our covenants, which were written by Clark Campbell, previous member of your board, I engaged him after the subdivision was approved to write the covenants. So he was very familiar with this subdivision and the way it was approved. So the way that was written, as far as the trees, not moving a tree, not cutting a tree down, going around the tree, he crafted all of that language. And that was our intent, was to just keep from clear cutting right up to somebody else's property, even though there's only 2 houses within hundreds and hundreds of feet of our property. We still didn't want to just go in there and buzz cut everything down. I did not want the builder to do that. So I think you would ask who he cleared the lots. I don't do any building in there, nor do I do any clearing or any of that. So I sell lots, and that's all that I do.
But you were also, excuse me, you were also involved in the revision to the declaration, conditions, and restrictions that removed the 10-foot landscape buffer
No, that was not removed.
as far as this property is concerned.
No, that was not removed. The revision was to clarify that it was only one type of fence. That has been in there from day one. The original covenants had fences go to the property line from day one. The revision was to specify there could only be one type of fence, the height, and there could be no double fencing, I think. That's what it was. But that did not, the 10-foot did not change. It was never in there.
So who cleared the lot all the way to the rear lot line?
Builder, I guess.
Beg your pardon?
Builder, I guess, but I don't do any construction out there. So that's the other issue, is we have a buffer, like Ben says, that there's no governance over that. There's no tree surveys required before a house is approved. So other than an aerial photo, it's kind of hard to say that it's been disturbed or not disturbed. which again was our hope that it wouldn't be cut down, but if nobody's going to check on it and the clearing guy goes out there and, you know, doesn't know any better, he's going to clear it, and there's nobody to say, you shouldn't have done that.
Well, it's pretty clear from aerial photography and on Google Maps that the lot was pretty well treed, all the way to the back property line. Okay. Any other comments?
So I'm curious why, if you were intending to sell this common area, because it was listed as undisturbed common area.
Well, it's not.
Okay. On section I, page 8, which is item number T of your neighborhood ordinance or homeowners agreement, it says the following areas as shown on the plat recorded in plat cabinet 17, slide 930, shall never be developed. 10-foot undisturbed landscape easement, open space 1.05 acres, open space 3.41 acres, and space labeled SCM between lots 15 and 14. And below that, these areas are common areas and are to be maintained only by the association. And I wonder how the association is going to maintain the back 10 feet of Mr. Stahl's property when there is a fence
'Cause
prohibiting that.
You're not understanding what you're reading. So those open spaces are in the front of the subdivision. These are not the 10 foot on each lot. That 10 foot on each lot is platted for each lot. We have multiple open spaces in the development.
The 10-foot undisturbed landscape easement is not the 10-foot landscape easement we're looking at around the perimeter?
Not common space. It is platted per lot.
Okay,
Those large open spaces up front are the open spaces that are referred to in those documents, along with the storm pond.
but item number I, or 1, is a 10-foot undisturbed landscape easement, which is labeled on the plat drawings as the perimeter of the subdivision, is it not?
Again, it is platted per lot.
Okay,
It might be deemed undeveloped property, which it is. There's no development in that 10 foot. But the HOA does not own that 10 foot. Each individual homeowner owns that 10 foot.
okay. But it says that these areas are common areas and are to be maintained only by the association. And I find that, I mean, that's what's written here.
I'm not saying that it's not. It's not the way that the neighborhood is platted.
Probably an error.
And then my second question is, when you went before council, why did you agree to this? Why did you not argue that the homeowners could have full use of their lots if you felt that they should be able to put a fence on that back property line? And, I mean, putting a fence up to me is disturbing.
There's nothing
Undisturbed
there.
would mean nothing goes on in there.
Well, I don't determine disturbing as removing scrub oaks, weeds. If there are pine trees, again, when I first came up here, I told you my goal was to keep from clear cutting lots. That's why we agreed to that 10 foot. And plus, it was something the village wanted. I didn't want it, but we had to do it to make it happen, so we did it.
Then you're not following through with it? You agreed to it, but
You can try to push this on me all you want to, but
Not trying to
there's
push
a
it on you.
10-foot vague reference as to what can happen. What is a landscape easement? Our goal was to not cut trees in that. And that's all I can tell you.
But though the builders are allowed to cut the trees if they so desire.
No, I don't have any idea. That's between the Village of Pinehurst and the builder. I don't govern that clearing. Nobody does.
David?
I mean, it's in the governance and restrictions pretty clearly and explicitly that it's common areas, if the other areas are common areas, then it's listed in the same bullet points under the same section of the covenants, so it's also a common area. The thing the covenants also do is I guess they govern less than what the ordinance does, which is not allowed. Because in the ordinance, you have that language. I'd say a reasonable interpretation of undisturbed is left as is, just what it is in the dictionary, not disturbed. In the requirement number 6, just below number 5, the one we're talking about, it says undisturbed except for whatever there is. If number 5 were to have specific inclusions in there, we're led to believe that it also would have included fences, septic, whatever else. But because it says undisturbed, it's interpreted most broadly as undisturbed, flat out. And are the ordinances intended to be read together as such, or are the separate provisions separate from each other? Alex?
No, again, I'm not a lawyer, so when these were crafted, I can sit there and read them, but as far as trying to determine whether something like this would ever happen, I have no idea.
I would read them as separate requirements and separate conditions.
Okay.
I mean, if the lawyer that crafted them didn't get it right, I'm not sure how I would be able to get it right. If he said that a 10-foot strip on the back was common area when in fact it's part of each particular lot.
Whoa.
Microphone, Jeremy. Microphone, buddy, sorry.
So whenever you went in front of council for your final approval, you brought in your general concept plan. And these lots were plotted on there as such with the 10-foot buffer inside of the lots at that time, right? So the council, of course, then approved it with that 10-foot buffer inside of the lots. Okay. So, but help me, you gave some good insight to maybe what your oversight of the development was. Help us maybe as a board to, on some insight of where the amendment to the covenant came from, and maybe the verbiage that's in there that states, walls and fences shall extend to the rear lot boundary line despite buffer reservations. I think that the board here would be glad to hear that.
Actually, I can't explain the word despite. Again, that would have been a word that Clark used. I'm not sure why it's in there. What we didn't want was one fence that was 10 foot from property line, one that was 6, one that was 2, one that was 15, and they just were all over the map. The only way to have a consistent line is if they go to one particular place that everybody knows where that is, and that's the property line. So that's why we wanted them to go to the property line. Unless, in fact, there was a tree that was in the way, then they were to go around that tree.
Could the same not be accomplished by going up to the edge of the 10-foot easement, though, as far as consistency is concerned?
Not necessarily with septics. All these lots are septic, so like he said, his fence may have been a different dimension from that 10-foot based on where his septic tank lines were or his tank. So it could be different, yeah.
Yeah, so my house, the septic lines run parallel to the back of the fence, where moving the fence 10 feet puts it on top of the actual physical chambers or pipes. The lot next to us has drain lines that run at an angle, 45-degree angle, basically off the rear corner of the house, running the opposite direction of our lot, at an angle that don't go anywhere near the rear property line. But theirs is a gravity-fed system. Ours is a pump with a distribution box in the back, and typically they run the distribution box back up to the highest point of the lot, which happens in our case to be the back of the lot and within that 10-foot area. So, I mean, that's why there's a drain field there.
But if the end of your property, if your property line had been 10 feet in from where your fence is now, they would have located the septic field within your property square footage, correct?
Well, the
Because you would
10-foot
not-
easement is still within our property because we actually paid for that.
I understand. I'm just saying, if
If the fence was already there, they would have known that and moved the septic system the
would've-
nitrification lines
Oh, I see what
further away from it.
You're saying if the fence was at a 10-foot location, they would,
Yeah, if the 10-foot easement was identified as common space and the septic lines could not breach that line, they would have adjusted where they located it in your yard because they would not have had any more property to deal with.
yeah, I would assume if it was advertised as common space, but the way this was advertised and the way it was purchased was that it was part of our property.
Right.
We were never told that the 10-foot buffer was, maintained by the HOA. We were told that, and my understanding of landscape buffers from prior dealings with them is that the intent was to preserve trees and substantial vegetation.
So Ken, answer this for us also. So whenever, maybe a perk test is done for a lot, there's only certain area that the septic tank can be placed, right? Are the lines coming from that septic tank also dictated by that area, or do they have a little bit more leeway?
I'm not sure what the county would say. So we had 28 septic permits before we ever did the development. But a perfect example is, so Ben's house has been changed, like he said, multiple times. So what we had approved way back when, location, certain linear feet of drain lines, where the tank was going to go, has been changed drastically based on maybe the number of bedrooms they decided to build on that lot, or where they placed the house compared to where we might have said it was going to, where we thought it might go. So that could affect where a fence could go, if you could even have a fence, if you were inside that 10-foot. I think the septic lines themselves are required to be a certain distance off the property line.
10 feet.
So again, they wouldn't get into that 10-foot no matter what. But the location and where and how a fence could go could drastically be impacted by the number of bedrooms on a lot, or on a house on each particular lot.
Joel?
Do I understand that 10-foot buffer was to be common area?
That was not my understanding.
That was not the understanding when it went through the P and Z or, well, I don't want to speak for council, but I know at least P and Z did not consider that 10-foot perimeter buffer, landscape buffer around the three sides of the property as common area. That 10-foot easement was individually owned by each lot.
It's included in our plat in the total square feet and what we paid for. That 10-foot strip of land, that 1,130 square feet is, we pay tax on it and we purchased it and, and again, it was about trees. What we understood to be common area to be maintained by the HOA, and I believe the CCR say that after it's 100% developed, it'll be turned over to the homeowners, is that large triangular lot parallel to Foxfire Road right there. And then, almost halfway down, there's basically a retention pond area. And that's what we understood to be common areas, not the 10-foot easement.
So if you had built the fence, or the builder built the fence 10 feet closer to your home, and from what I see, your fence pretty much encompasses your lot, who would have maintained the buffer?
Who to maintain the buffer?
Yeah.
It's usually generally a landscape buffer and easement. Again, what I'm familiar with
Yeah.
is it's not really maintained except for trees that are dying or pose a event of damage or injury. You could always supplement to that, add additional shrubs, bushes, trees, provided it's not things like, the popcorn trees or invasive species. And so homeowners would be, generally speaking, most HOAs, that's what that means, is that they can add to it, but you can't say, I don't like pine trees and decide to cut them all down. So it would be left alone in essence, which is really what we've done. And again, there's nothing really there to leave alone. It's, there's nothing.
Are there any more folks in the audience who would like to say something? In the audience? Yes?
Can I say something real quick? When the easement was decided upon, who has the right to enforce it? As the property owner where the easement is located, you're typically servient to that easement, which means somebody benefits from that easement. Was it for the neighbors? Was it for preservation of land, view lines? Is there any information regarding the origin of the easement?
No. Have your name and address,
Black Kalinsky, 25 Queens Court.
and you swear to tell the truth, the whole truth, and nothing but the truth?
I swear to tell
Yeah.
the truth, the whole truth, and nothing but the truth.
Thank you.
I do have a question. You say there's no records, and if I'm correct at when this was approved, it wasn't in this room, so there weren't visual records, but if I'm correct, the reason, and he stated, they did not want to put the 10-foot buffer in was because even though they have the common area out front, it wasn't enough, if I think I'm right, to get that many lots in that area. That common area out front was not enough to be accommodated, so they had to put the 10-foot buffer in. And that's the way I recall it. So if somebody else has something different or there's different records, so be it. But that's the way I remember it when it was approved. Thank you.
Your mic went off. Yep.
Are there open space requirements?
Yeah, so I can speak to that real quick while we work on getting Chair Sanawaso a new mic, and be gentle with your new one, Leo, please. Poor Kelly. So with new subdivisions, and with this one in particular, there was an open space requirement. If you're going to provide that open space, then you kind of get the reduction in setbacks and reduction in lot size. With this subdivision, however, much like other subdivisions that we're having in our ETJ, it is located within a public water supply watershed, so the density there is limited to 1 unit per acre. You may recall that the original zoning of these, there was 2 parent tracts in which the subdivision was subject to, was zoned R210. The conditional zoning was down to an R30 conditional district, which would be a minimum of 30,000 square foot lot size base zoning. If you do the open space requirement, then you could go down to, I believe it's 24 or 26,000 square feet lot sizes. But there again, because it's in a watershed and the density being limited to 1 unit per acre, there you have the much larger lots that are associated with this subdivision. So open space provided, yes. Met the PDO, yes. But also even much larger than what could have been applied to this subdivision because of the watershed density regulations. So they had more than enough area.
Any other folks? Yes, ma'am.
I'm Margaret Lovett, and I am 224 Foxfire Road, and my property adjoins the right side and the back side of these lots.
Do you swear to tell the truth, the whole truth, and nothing but the truth associated with this application?
Yes, I do.
Thank you.
Of course, I'm pretty familiar with all that's going on. And I guess I was the complainant. Now, I didn't call when this gentleman put his fence up because I said, well, it's just one fence. I can live with one fence on my property line. Now, if you think about it, and when you look at the picture of the fence, the boards that are up and down are to the outside of the fence. Now, how do you nail those boards to that fence if it's on the property line? Well, and then the other lady started putting her fence up, or had someone out getting ready to put the fence up, and that's when I called. I don't know the dates. I'm too old to remember what today is. But I don't know about you guys, but I think they need an area where they can walk around their fence without walking on my property, without nailing nails on my property, without driving a truck into the back of this fence. Now, it's just one of those things that I didn't think would ever happen because like you said, we were zoned that you had to have 5 acres to put a house on. And Mr. Bass managed to get the zoning changed. Now, how he did that, I don't know, because everybody that I knew always said, you'll never get the zoning changed, and you'll never sell your property. And I'm assuming that's true. I'm assuming also my property is still zoned 5-acre lots. I don't know that for sure, but they haven't told me if they changed it. But I sympathize with Mr. Stoll. I always pull for somebody who's fighting against, I don't want to say the government, but against odds. Anybody who's fighting against odds, I sympathize with. But again, they have to see the necessity to be able to get on the backside of their fence without walking on my property. Now, I know they think, well, I'll never have to do that. But that's not exactly true, because they had to do that. Somebody had to do that to put the fence up. Somebody would have to do that to put every one of these fences up all the way around my property. And that's all I have to say.
Thank you. All right, we're going to have to close the public hearing pretty soon. Go ahead. Do you have any more comments? You're already sworn.
So me being a homeowner and the first homeowner, now I feel like I have to jump in even though I don't have a fence. When I purchased my home with my husband, we were asked, do you want a fence? It will cost such and such. We said no. My husband's military, we weren't going to be here long, and I wasn't going to add that cost to my home price. But I just wanted to speak because you spoke. If the fence went up like Ben's went up, we have nothing to do with that. It was whoever the builder contracted to put up these fences and all of that. It had nothing to do with homeowners. You know what I mean? So now, when I sell my house next summer, I don't know if I'm going to come across this or if a new person buying my house goes to put up a fence, if they can then sue me. Because we're selling it how it was sold to us. You know what I mean? This is going to be a domino effect. Just wanted to add that.
Thank you. Anybody else? All right.
I just want to, Mr. Bass, is that true that all homeowners are given the option of building a fence on the property line when they purchase a lot? And there's no conditions when you sell to the builder?
If you guys are going to continue, we need to get this on the record. Sorry, Ken.
I'm sorry, to answer your question, I don't have any interaction with people that are building houses. I only interact with the construction company when they buy a lot.
And there's no guidelines or stipulations to the construction company concerning the easement?
They have the same thing that I have, the same guidelines, the same plat, village ordinances.
I want to add one other thing that I don't know that everybody in the room is aware of as far as this development. Our mailing address is Aberdeen, okay? So we advertise, or this development is advertised as Pinehurst 28374. That's what we paid for. We live in Aberdeen 28315. Now we pay some bills and we get some of the frills of Pinehurst, but we get a whole lot more of the aggravations and lost mail, not receiving packages. I'm still not clear about emergency services. We're reassured that it's Pinehurst, but we're not sure because Aberdeen has showed up out there. I've never seen a Pinehurst police car out there. So it's a little disheartening where we're held to a higher standard on a lot of things. And then, we're into this mix and we're advertised with a piece because that was one of our criteria, had to be Pinehurst. The website specifically says Pinehurst 28374. okay? The closing documents from our closing attorney did not get to us, okay? Because they used the wrong Pinehurst 28374, all right? We did not get the letter from the city after numerous verbal conversations because it was mailed to Pinehurst. So there's a lot of confusion. My driver's license says Pinehurst. So we get Pinehurst trash pickup. Other than that, and the letters and this aggravation around the easement piece of it, and we like Pinehurst, don't get me wrong. The problem is that we're kind of like on this outskirt. We're not considered Pinehurst. Nobody considers us Pinehurst, but we're held to a higher standard on that. And it is a little frustrating with mail and driver's license, where do you live? I mean, I've even reached out to the postmaster to say, can we at least put Pinehurst 28315? And they don't want to do that either. So when we say we live in Pinehurst, we really don't. When somebody sent, I can't tell you how many times I've had, wait, I thought you said you live in Pinehurst. This is Aberdeen. Well, it's confusing. It's, for tax purposes, it's Pinehurst, but it gets mailed to Aberdeen. So, I mean, there's a lot of confusion around this whole thing. I mean, it boils down to everything from addresses to this easement. And I would suggest that future is that when something gets annexed into something as Pinehurst, it needs to be called Pinehurst. Because I can call this a dog. It's not a dog. And it's very frustrating for everybody in the subdivision. We did not find out it was Aberdeen until the day we closed, to be clear.
Point taken. Unfortunately, we can't do anything about it. And unfortunately, the individual citizens don't have much pull with the Postal Service either, so.
No, and I get that piece, but we're held to a Pinehurst standard, but we're surrounded by, people, shooting guns all day and night, and chickens cackling, and dogs barking all hours of the night, and we can live with that and all. But then all of a sudden now we're subjected to, this draconian decision about, this easement piece. It's, kind of after the fact, and I just hope it gets resolved, because it is a big issue for every homeowner there and adjoining property owners, because they have one understanding, homeowners have a different, and then it's causing, we definitely don't want conflict between neighbors, surely don't want that, but.
If it's any consolation, you're in the Pinehurst extraterrestrial jurisdiction.
Well, my driver's license doesn't say that.
That's why I say,
Do I understand, though, just to be clear, that one of your stipulations was that you get a residence in Pinehurst?
That's correct.
Okay. I just, thank you.
That was the number one, by the way. Because of covenants and restrictions in the city, we like the way, if you went through Pinehurst, it was, clean, crisp. You didn't have weird things in the front yard or, cars on blocks and such, so.
Can I ask one question? Alex, under normal circumstances, could these homeowners approach the village with a variance request for their specific cases and fence request?
If it were relative to any condition that was placed on a conditional district approval, no, sir. A variance is not an avenue in which they can take, which is somewhat another reason in why we are before you guys now with an appeal on the determination.
And this property was annexed in?
This property was annexed in and was petitioned to and was also part of that conditional district request. So this, I don't think it's germane to the appeal that's before the board here, but the property is annexed in. It is surrounded by extraterritorial zoning and planning jurisdiction of the Village of Pinehurst. However, it is addressed as an Aberdeen mailing address. So any mail that comes to these properties has to go through the Aberdeen post office, and it's confusing, and it has been. We've noticed it when we notified for this public hearing that Moore County addressing still has some of the lots. They've corrected Mr. Stahl's property now, but there are some lots that were notified that we sent notification of this public hearing to that still had a Pinehurst mailing address, and it's incorrect.
Do
So
I
it is
understand, though,
unfortunate.
that, I'm not being rude, but none of this that we're discussing here with, whether it's in Pinehurst or Aberdeen or ETJ or whatever, has any bearing on this case whatsoever?
that's correct.
No, sir, yes.
I think you're right.
He's right.
Can I have a motion to close the public hearing? Motion by Joel, seconded by
Second.
Cindy. All in favor? Aye. Opposed? None. You want a 5-minute break?
3-minute break.
We'll recess for 5 minutes. Everybody be back by 5:45, please, and thank you. Hearing was reconvened at 5:45.
Thank you.
The public hearing has been closed. We have a motion that was already made to go into our regular meeting for the purpose of board discussions, deliberations, and determinations and action. I want to remind the board that we are convened tonight to take action on an appeal from an administrative action. And the board can do one of three things. We can affirm the action by the administrative officer. We can deny the action taken by the administrative officer. We can always ask for more information. To perhaps modify any motion that's made, but I don't think we're at that point yet. We need to do some discussion amongst ourselves so that a motion can be formulated and acted upon. And I'm going to go around the room again from left to right, what I'm looking at, for comments, questions, deliberation. Jeremy?
So it's not fun going first, Leo. Maybe we can go right to, I'm not trying to make light. This is a tough situation, and golly, it's not a fair situation.
Let me also add something else.
Please.
We're not here to change an ordinance. We're here to deliberate action taken by an administrative official. Okay. He'll probably welcome that.
Please do. Yes.
There we go. So page 4 of section A, item D, under action by the zoning board of adjustment, says the zoning board of adjustment shall not reverse or modify the contested action unless it finds that the administrative officer erred in the application or interpretation of the terms of the ordinance or related policies adopted by the village. Can you tell me what that means? I mean, I think I know what it means, but.
Well, I can't, but hopefully can.
All right, so what that means is based on the evidence presented, testimony given to this board by those who are in attendance and with the exhibits provided within your packet material, if you feel that the zoning administrator or the village staff erred in making the decision that was then appealed and then brought before you guys, that's how you reverse or modify it. That's you affirming as a board or as a majority of the board that staff didn't apply the regulatory provisions correctly. So in other words, we erred in how we came at that determination based on the evidence presented to you. If you were to, if you did not think staff erred in making their determination, then you obviously would affirm it. So it's just sort of solidified language that whatever your action is based on that.
So my question based on what, and this is to you, based on what Leo just said, is make the assumption, just for discussion, that we decide that the administrative officer erred. And now we're going to do what? I mean, you just said we don't have the power to change an ordinance.
You could reverse or modify, and however, it's not just that you're seeking the determination by the zoning administrator. It's how that regulatory provision was applied. So this would, in essence, whatever is ruled here would be then that interpretation bound forward on this particular condition. So this wouldn't necessarily be just for a fence particularly located and it can be located in that undisturbed 10-foot easement for 822 Winston Pines, subject parcel ID included. This would be for that regulatory provision, that condition number 5 with ordinance 1712.
So this would change the conditions of the buffer zone.
Yes.
And how do we have
It doesn't change the condition, it changes how it is interpreted and then ruled.
how do we have the authority to do that? We're changing an ordinance, or we're altering an ordinance.
I'll read it, you want me to read it verbatim from the ordinance? It may help, maybe, instead of in my words, you hear it from the ordinance.
Okay.
The ordinance?
All right, so section 5.3.6, effect of reversal or modification. This is under appeals of actions by the zoning administrator in the Pinehurst Development Ordinance. In the event that the zoning board of adjustment reverses or modifies the contested action, all subsequent actions taken by administrative officers with regard to this subject matter shall be in accordance with the reversal or modification granted by the zoning board of adjustment. Yes, sir.
Buffer. So really where I was going is I'm trying to determine in my head where possibly Darren, sure, but Will, I don't speak loud always either. Maybe where Darren erred in the decision that he made in relevant to the PDO and the ordinances. That was why I asked the questions earlier. Were there any other outside governing powers that maybe directed the village and what their actions should have been? I'm still struggling a lot with that. A very compelling case from Mr. Stahl, and I don't know what I would do if I was in his situation. However, when we're trying to make the decision on whether or not Darren's decision was an error or wrong or right, we come into the topic and the term undisturbed. And I think maybe how we maybe define that as a board is going to be relevant to this situation going forward. I think that's what maybe the outcome of your question. And so although many people can feel that that's a very vague term, I would almost argue that it's a very well defined term. And I just feel that within that broad definition is structure. And I think that given what the staff had, given the PDO, and given the terminology, I'm trying to find error in their decision. So that's really where I'm at, and I don't have a lot more questions, just a statement. So I'll move from there.
Okay. Joel?
So in the packet, it states somewhere, maybe you can help me, that staff determined that an error was made. and so you were going to find a compromise solution to this. The village would pay Mr. Stahl to move the fence if et cetera. Am I correct?
You are correct.
I'll go back to page 4, section D, action by the zoning board of adjustment. The zoning board shall not reverse or modify contested action unless it finds that the administrative officer erred in the application or interpretation of the terms of the ordinance or related policies adopted by the village. The village has admitted that it erred, otherwise it wouldn't be paying, I'm assuming, to move his fence at the village's expense. And that's all there is to this to me. Where did this error come? And so if I go back to the beginning and follow this all the way through using your timeline, so the builder says to Mr. Stahl, your fence has to be 10 feet from your property line. We probably wouldn't be here, I can't say for certain, but we probably wouldn't be here because Mr. Stahl has stated he wouldn't have bought the property. So
That's not,
there were a series of,
that's not the action that's being appealed, though. It would take another landowner to challenge the granting of his fence to challenge that decision.
sorry,
That's not the action that's being appealed. It's Darren's action saying, comply with the ordinance that's being appealed. That's a previous action that's not at issue.
you don't think that's the issue?
I think it's an issue, that's not the issue that we're being asked to
I think the
discuss.
only reason we're here is because somebody in the village of Pinehurst issued a fence permit in error.
Yeah, there are two separate items here. Initially, yes, a fence permit was issued for Mr. Stahl's property, as depicted on the application, which is just shy of the property line and thus within that 10-foot easement. Then we later determined as staff that that fence permit was issued in error, the fence permit itself. And thus we had to make an official determination that fencing therefore cannot be located within that. And that action is, as David said, is what's being appealed and before consideration of you guys. The action on the fence permit itself on October 1st, 2019 is not the action that is or has been appealed. And the 30-day window has subsequently passed. So the ordering of the fence out and determining that fencing cannot be located with a 10-foot easement is what has been appealed and before this board in this meeting today.
But if the village had not erred in giving the permit,
This thing is a case of unclean hands, if you want to put it that way, not only on the village, but also the developer, in my opinion. And Mr. Stahl is left in the middle.
I agree.
Okay, but it's not only the village that made the error. The village made the error of omission, not commission.
I was about to say.
I'm going to say the same for the developer.
Yes.
Although I have an issue with the way that the covenants were revised to be a little flaky, in my opinion. Okay.
But it seems to me that if A didn't happen, the issuing of the permit in error, we might not be here because I don't know that Mr. Stahl would have bought the property. And I don't know any reason to state that, except that's what he said under oath he wouldn't have done.
And I think Chair Sanawaso said it
Okay.
as about appropriate as you
But
could.
I think there's enough blame to go around here. We don't need to. We're certainly not going to parcel it out. Thank you.
Would you take off your mask when you talk? I have trouble understanding you. Thank you. Go ahead.
Yeah, as far as the decision that we're being asked to look at, the plain language of the ordinance, as it was applied here, it's tough to go against that. It's tough for me to say that it was interpreted incorrectly. Again, the fence permit likely should not have been issued in the first place, and that's why the village is offering to pay to relocate it. If they'd issued it correctly in the first place, we wouldn't be here, but because the village is the one that erred, they're not saying relocate this at your own cost, they're participating in the remedy, essentially. But as far as misapplying the ordinance, I don't think there was any error there.
Let me just point out that we might not be here, I say might, if the septic system wouldn't interfere with moving the fence. So, I mean, as I say, as Leo has said, there's plenty of blame here, and I'm not going to blame the septic guy, because obviously if the fence had been put 10 foot closer, the septic system would have been moved 10 foot back.
Or if the fence
And
was put in
We may not be here
first.
because they're going to move it, but
Yep.
all of that is coulda, woulda, shoulda, and
Yep.
I don't think has any bearing on what we're doing now. I don't see punishing people when they didn't create a problem.
Cindy?
I think it's pretty clear. It says shall remain as undisturbed, and I believe that the village made the correct interpretation. And I'm glad to know that they are willing to work with the homeowner. But moving forward for the other lots, I think it's very clear that it should be undisturbed, and especially for the neighbor, Margaret, she has a good point. We have a buffer to protect the other landowners around this subdivision. And so there's a reason for it. And so I think the interpretation was correct.
I don't know what I can add, other than there's got to be a resolution of the problem that we can't resolve for the individual property owner at this point. But I believe he has other avenues that he can take to get the particular problem resolved. If the decision that we make is that we're going to support the decision that was made by the administrative officer. And whether that's not going to really satisfy anybody, but I believe that's about all we can do under the powers that we have as the board in this matter. So,
Can you usually provide us with some.
Thank you, Joel. You're timely as ever. I did want to interject before any motion or decision that may be rendered by this board. Included within the staff report, Exhibit A, as usually, there is a draft order and findings of fact with conclusions of law. If you start on the second page with the findings of fact, there are 9 items there that would need to be read into the record as evidence that's been presented by both the applicant and staff this evening. And then under the findings of fact and the conclusions of law, there are 2 items that have areas for the board to decide that are underlined and italicized for you. And the next paragraph is therefore, it begins therefore, there's another item that is underlined and italicized. Please place your findings. It helps, I think, if you circle along as you go through and make the motions, but we need to make sure that those findings and conclusions of law are clearly made in the record.
I want to also add that any decision does not require a supermajority. It requires a simple majority. That would be 3 out of 5 for any action the board may take to approve. Joel, you have a motion.
You all want to read along, it's Exhibit A, findings of fact. Mr. Stahl owns the property at 822 Winston Pines Drive, also identified as Moore County PID 201805553. The property is zoned R30 CD Conditional District under the Pinehurst Development Ordinance, as shown on the latest official zoning map and further described in Ordinance 17-12. A contractor submitted an application for and was issued a permit from the Village of Pinehurst Planning and Inspection Department on October 1st, 2019, to construct a fence in the rear yard of the property and within the labeled 10-foot undisturbed landscape easement. On December 27, 2019, the Village of Pinehurst Planning and Inspection Department received a complaint that a fence was being constructed within the 10-foot undisturbed landscaped easement. After an inspection confirmed the complaint, VOP staff noticed the issue. Permit was not compliant. On February 11, 2020, VOP staff contacted the contractor to inform them that the fence would need to be located outside of the 10-foot easement. On February 14, 2020, the contractor stated that the property owner was requesting VOP staff to communicate directly with them regarding the fence placement, therefore turning the matter directly over to the property owner. On March 13, 2020, Darren Burrich, VOP Planning and Inspector Director, sent communications via email to the property owner stating the options to comply with the conditions and the placement of the fence. On March 20th, 2020, Darren, VOP Planning and Inspection Director, also acted as the zoning administrator, issued a signed final determination letter of how to comply with the necessary conditions of the fence location. This letter was sent to the appellant, Ben Stahl, property owner Ken Bass, Bass Design and Development LLC, developer of the Winston Pines subdivision, and Cavanis and Cates Building Development Company, current home builder and lot owners within the said subdivision. Due to mailing and addressing issues, the property owner received the signed determination letter from VOP on April 1st, 2020. On April 27, 2020, the Planning and Zoning Department received an application to appeal the decision of the zoning administrator. Based upon the following findings of fact, the board makes the following conclusion of law. The fence at the property addressed at 822 Winston Pines Drive, PID 2018053, does comply with the condition number 5 on the ordinance 17-12 for the conditional district rezoning. The fencing can be allowed within the 10-foot undisturbed landscape easement. Therefore, based on the foregoing findings of fact and conclusion of law, the board reverses the decision of the zoning administrator. You wrote all that down.
That's the motion. Do we have a second? We have no second. The motion dies. Thank you. Anybody else have an alternate?
Can I just state that based on the same findings of fact, the board makes the following conclusions of law. The fence at the property addressed at 822 Winston Pines Drive, PID number 201-80553, does not comply with condition number 5 on ordinance 17-12 for the conditional district rezoning. Fencing cannot be allowed within the 10-foot undisturbed landscape easement. Therefore, based upon the foregoing findings of fact and conclusions of law, the board affirms the decision of the zoning administrator.
Thank you. Do we have a second?
Second.
Motion by Cindy, seconded by David. I'm going to do a roll call vote. Jeremy?
Yes to that motion.
Joel? No. Cindy?
Yes.
David?
Yes.
And I vote yes. Our business is concluded. Unfortunately, not everybody's very happy, but there's going to be.
What is it that I'm supposed to do with this fence now?
Right now, until you have some discussions, perhaps with staff, they can direct you,
I can't put it in a drain field. We just sell the house.
well, I can't answer that. The decision has been made, however, I believe you do have some remedies that you can pursue with the builder, if you would prefer to do that, but that's your decision otherwise.
We have to have a septic system for a home. We're not on city sewer.
You already have a septic system, right?
Fence would go into the drain field. You cannot put a fence inside the pipes of the drain field.
That one line can be relocated.
Then it goes into my makeup area, which I don't have. There's a repair area that's designated for the septic tank. Once you use that, it's gone. So then the value of your house goes, because when you get a plot and you get a septic permit and a septic inspection, you have a primary area, you have a makeup area. When you relocate to the makeup area, your lot is gone. There's nowhere for sewage.
Yep,
Excuse me, we have no business in this discussion.
true.
All right.
Just want to notify everybody that the next meeting is October 1st, 2020, if there's any business to conduct. Motion to adjourn. Second, Joel. Cindy made the motion. We are adjourned.
It was pretty tough.